Thank you, Tamsin, and can I also say thank you, Xavier, for the opportunity to speak at this conference at a society that I've been a member of for 10 years now, and a decision I've never once regretted. Can I also acknowledge the great work of Stuart for this society, if he's in the room. And finally, I'd like to congratulate Mr. Ian Callanan, not only for your great service to the country and your great service as president of this society, but in finally convincing Stuart to allow you to resign after all these years. Unfortunately, I have a bit of a sombre topic because the reality is Australia's legal traditions today are in crisis. Australia was founded on the idea of constitutional government, the division of powers, and the protection of the individual against the excesses of state power, also known as the rule of law. By 2024, Australia has just exited a period in which unprecedented use and abuse of state power was wielded against the Australian people without any intervention from the courts. Over decades, almost every nook and cranny of the Constitution has been transformed beyond what anything the founders would have foreseen. And as James Allen explained yesterday, the law schools are producing graduates to be the next generation of lawyers and judges steeped in social justice doctrines and ignorant of the virtues that Australia was founded upon. Conservative-minded people have done a very good job of diagnosing the problem of Australia's courts and identifying the need for Australian governments, state and federal, to appoint better judges. But this raises the inevitable question: what is a better judge? What are the qualities or values that a judge possesses that would make them satisfactory to address the problem of legal progressivism? I would argue that legal progressivism, if the antithesis of legal progressivism is legal conservatism, the topic of my talk today, that this is an idea and a doctrine that has not been sufficiently developed in this country. Indeed, in a speech to this society in 2019, then High Court Justice Geoffrey Nettle expounded on the legal conservatism of former Chief Justice and co-founder of this society, Sir Harry Gibbs. While this is a topic upon which there is much fertile ground, the speech itself was actually very light on the topic of Sir Harry's conservatism. Much of the speech focused on the role of the judge, the role the judge played on the court in curtailing the right of Australians to appeal to the Privy Council. Now, the merits of these developments can be debated, but it must be said that the changes were not a worthy example of Sir Harry's conservatism. For one thing, the Australian Constitution acknowledges that appeals to the Privy Council would be a feature of Australia's judicial structure, and closing the door on this appeals path meant something was being lost, not conserved. Moreover, making the High Court the last court of appeal in Australia has not led to conservative decisions from the bench. So with the benefit of hindsight, we can conclude that even on an outcomes metric, the reforms were not a win for Conservatives. That a sitting High Court judge could speak to this society and fail to represent legal conservatism in an even approximately accurate way highlights that there is much work to be done to develop a coherent vision of the doctrines of legal conservatism to counteract legal progressivism. The purpose of this paper is to lay out a framework for legal conservatism that would address many of the problems that we've heard about this weekend, that is in a framework that is consistent with the history and the traditions of Australia's founding. Now, I do not need to labour the point at a conference such as this, but Australia's judicial class is fundamentally activist. But it is the kind of activism that is dressed in the type of legal language that has the appearance of law, but really disguises the exercise of arbitrary and discretionary decision-making that allows courts to intervene when they are not wanted and remove themselves when they are needed. James Allen, to mention Jim again, summarised the problem well about the use of proportionality analysis, where judges create an unendingly flexible standard that only they themselves can determine has been met. And so it is that you can get a body of decisions from the High Court that says simultaneously that banning political donations over a certain amount from trade unions breaches the implied constitutional right of political communication necessary for a democracy, but a separate judgment finding a law that limited political donations from property developers was not only valid, but affirmed that it was good for democracy. Recent years have shown that judicial activism has not only been expressed in terms of intervention, but a failure to intervene, when the argument for intervention was compelling. To find numerous examples of this, one need only consider the numerous challenges to public health rules during the pandemic. Not one court made a decision that went against public health orders in that period. In the Loyallo case in Victoria, the Victorian Supreme Court held that a test of whether a public health official's decision to impose a curfew was reasonably necessary to eliminate or reduce a public health risk as required by the legislation was at least in part answered by the public health official making the rule. Essentially, the person making the rule determined whether it was lawful. It was a stunning abdication of the court's responsibility to act as a check on the power of the executive in Victoria at a time it was exercising unprecedented and draconian powers. What makes the Love Toms decision by the High Court so noteworthy was not that it was an unprecedented act of judicial activism. This is wholly unsurprising. What was surprising to me was that the reasoning adopted by the court. The High Court has made an art form of using and abusing legal language to make its decisions appear well-reasoned. But in the Love Toms case, the court for the most part abandoned the pretense of reason when it held that two foreign citizens who had Aboriginal ancestry who committed crimes in Australia were not able to be deported like other non-citizen criminals because their race rendered them in a quantum state of being both non-citizens and non-aliens. The claims by Justices Gordon and Edelman that Indigenous Australians had timeless metaphysical ties to the Australian continent was as close as this country has ever gotten to having a mythical Flora and Fauna Act. This is all to say that despite the abstruse legal language used by many judges, all judges make decisions based on values. And Conservatives have a choice between a conservative conception of the law or to abandon all values and reinforce the progressive status quo. Allow me to explain with reference to some ideas that some Conservatives have put forward of a values-neutral approach. Literalism. I think we're probably well aware of the problems of literalism, but literalism refers to interpreting text according to its plain reading. In other words, the Constitution is what it says it is. This has the benefit of simplicity, but as we know, this was the method Justice Isaacs used in the Engineers case in 1920 to finally rid Australia of the reserve powers of the states. One of the consequences was that it confined Australian federalism case law within Australia and entirely divorced it from the American case law upon which much consideration was given while Australia's own federal system was being devised. Literalism is based on the dubious premise that words can be understood without any bias or subjectivity, but what it really offers is a more polite version of living tree constitutionalism that we as Conservatives should reject. This was highlighted in recent years during the so-called citizenship saga, where the High Court disqualified 5 federal parliamentarians on the basis that they met the constitutional definition under section 44(1) of being a subject or a citizen of a foreign power, and thus incapable of sitting in either House of Parliament. The High Court found that this set provision imposed a strict requirement on all MPs to be clear of any potential hint of foreign allegiance, including in the case of Barnaby Joyce, the member for New England, that despite being born in Australia and despite his New Zealand-born father moving to Australia prior to New Zealand even legislating its own category of citizenship, that he was a subject of a foreign power. By adopting a literalist approach, the High Court followed the precedent in the 1992 case of Sykes and Cleary, and the effect of which is that citizenship is interpreted according to its present understanding, and to completely disregard that the provision, to disqualify elected representatives no less, was drafted at a time where concepts such as Australian citizenship and dual citizenship were not yet imagined, as well as the documented evidence that constitutional drafters contemplated that Section 44 contained a requirement that a person exercise an active allegiance to a foreign power, not be a passive recipient of it. The case shows how literal reading can produce a dramatic change of the meaning of constitutional text. In other words, it's a living tree. The other approach that has been put forward is legalism or black letter law. This is in the tradition of Sir Owen Dixon, who is rightly regarded as one of Australia's most eminent jurists, and his assertion that the common law was the ultimate constitutional foundation ought to be taken seriously. But it is also the case that Dixonian legalism has not turned the tide on judicial activism, nor has it inspired an energetic view of legal conservatism. One of the key elements of legalism is strict deference to precedent. This is a fine idea, but it runs into trouble if the precedent you are deferring to itself has no merit. Even Sir Owen himself reinforced judgments, such as the engineer's case, as well as another Isaacs innovation to supercharge Section 109 by making fully authoritative the cover the field test. What this means is that Section 109, which provides that Commonwealth laws prevail over state laws to the extent of the inconsistency, applies even in cases of indirect inconsistency, so that as long as the Commonwealth intended to have exclusive control over a policy area, the states would be excluded, even if both state and federal laws were capable of operating concurrently. Legalism also imposes qualities of restraint on judges. Now, judicial restraint is a fine idea and it's fine if the restraint leaves more power to the legislature, then it's a fine democratic theory too. But the reality is not so simple. A status quo approach, a restrained status quo approach, merely allows prior activism to persist and become entrenched. A reliance on precedent is in theory a good premise, but only if the precedent is worth abiding by. But we now have a century of decisions departing from the founding principles of Australia that have become like legal tumours which must be cut out to restore the body to health. In other words, we as legal conservatives need to reject any insinuation that overturning precedent is conservative judicial activism. It is restoration, it is necessary, and it is overdue. So what I would like to put forward is, rather than a values-free framework, legal conservatives need to adopt a values-based framework. And fortunately for us, conservative values are fully compatible with the common law traditions and the values of Australia's constitutional founding, meaning we don't need to make it up. This paper proposes that the approach would illustrate this approach through 4 principles that are consistent with rule of law principles and that would limit the centralisation of power and protect the individual against the excesses of the state. Now, the first principle is originalism. If we are to resurrect the legal traditions of Australia's founding, then the first step is to bring back to life what those responsible for Australia's founding actually believed. This encompasses the intentions of those who drafted the Constitution as revealed through the records of the constitutional conventions and other supporting materials, as well as the public understanding of the terms used in the Constitution. After all, it was the people of the colonies who endorsed the Constitution at colonial referendums. Non-originalism is in essence blatant judicial supremacy because it presumes that by discarding intention, that a law or constitution actually has no meaning until it is given meaning by a judge, usually according to contemporary values or the needs of the government of the day. This way of thinking undermines the rule of law by conferring broad discretion on judges to reshape the law and is also undemocratic. The Constitution is clear that the only valid method of constitutional change is by Section 128, referendum, not by judicial elites through the back door. Now, originalism is very important, but it is not fully comprehensive. Originalism wouldn't have accomplished much during COVID lockdowns or to constrain regulators who are given a broad grant of power by the legislature. Therefore, another principle that legal conservatives should embrace is a presumption against executive power. The executive branch of government is responsible for administering the King's laws, but it is intrinsic to the rule of law that the executive does not have free rein to exercise arbitrary power. It has been said that Australian courts have not adopted a formal doctrine of deference to the executive, similar to the US Supreme Court's Chevron doctrine, which means that a court will defer to a regulatory agency's reasonable interpretation of an ambiguous regulation. Arguably, Australia's own Hickman doctrine, though, is directed towards a similar purpose, although the extent of its application is somewhat unclear. At the very least, Australian courts have adopted a position of quasi-formal deference to the executive. In Atherville and New South Wales in 2021, the federal court said, in matters of public policy, these choices require a balance between competing interests. It is a matter for the executive and not the court to strike that balance. This reasoning was affirmed during the COVID period by the Supreme Court of Western Australia, rejecting a challenge to the exercise of public health emergency powers. A conservative approach, in my view, should actively and forthrightly apply tests of strict scrutiny on the executive to require the government to justify that the exercise of executive power is based on a rule that is validly legislated and lawfully conferred. The next principle, somewhat related, is a principle to give preference to the individual. Where a dispute involves individuals and public bodies, a court should always prefer an interpretation that benefits the individual. This is consistent with common law presumptions and the principle of legality that provides legislation drafted in ambiguous or general terms is not intended to deprive a person of their rights and liberties. But while courts have often quoted the principle of legality, its application has, in my view, been found wanting. As former Chief Justice Murray Gleeson has noted, modern legislatures regularly enact laws that take away or modify common law rights, and that the utility of the principle will vary with the context in which it is applied. I think, in my view, a legal conservative should adopt a more assertive view of common law rights. One can measure the decline in consideration for the individual in High Court decisions over the years. Whereas the Constitution's mandate that trade and intercourse between the states be absolutely free under Section 92, whereas this was once given a broad interpretation as an individual rights provision laying down a general rule of economic freedom, this section has been hollowed out so much so that a Western Australian law that fully closed the state border to all other Australians was deemed valid and met the standards that this was absolutely free intercourse between the states. That's, again, that proportionality analysis at work. This principle could also be demonstrated in other areas of the law. The dismissal of Dr. Peter Ridd by the James Cook University for questioning the quality of science, asserting that climate change was killing the Great Barrier Reef, was a case in which Dr. Ridd's contractual right to intellectual freedom was said to be in conflict with JCU's code of conduct requiring university staff not to harm the reputation of the university, among other things. On appeal, the High Court unanimously held that JCU's initial disciplinary proceedings brought against Dr. Ridd were unlawful, but the university's order for Dr. Ridd to keep confidential the unlawful proceedings brought against him were valid. And by breaching those confidentiality provisions, his dismissal was valid. This by itself is logically absurd. Doubly absurd was that it was ambiguous at best whether the confidentiality provisions even applied in Ridd's situation. As I write in the book, Peter Ridd and the Case for Academic Freedom, the content and structure of Dr. Ridd's employment contract, which contained rights of natural justice, should have led the court to decide that the confidentiality provisions were for the benefit of individuals who were subject to disciplinary proceedings and not for the benefit of a university targeting a staff member. And a final note about the presumption in favour of the individual, because I couldn't let this occasion go without talking about last year's referendum. I need to mention the ticks and crosses case. Prior to the October referendum, a challenge was raised against the Australian Electoral Commission's intention to count ticks on a ballot paper as a valid yes vote, but crosses as invalid votes. The AEC's position defied logic. At a referendum, electors are asked to write their voting intention on the ballot paper by writing yes or no. The AEC was arguing that in response to a yes-no question, A cross could be construed as meaning yes, and was therefore ambiguous. This manufactured ambiguity, intentionally or unintentionally, would give favouritism to the yes side in the counting of a referendum. Instead of endorsing the AEC's view, which it did, the federal court might have instead considered that it is the role of voters to decide electoral outcomes. As Sir Samuel Griffith said in a 1904 case, if a court is called upon to use the extremist technicality in construction, I think we ought to use it in favour of the franchise rather than against it. Finally, I would finish by saying that any conservative approach to constitutional law must incorporate a preference in favour of the states in cases where the powers of the Commonwealth and the states are concerned. I won't speak at length about the merits of federalism, as it is a principle upon which we are all somewhat familiar, I feel, but allow me to make a few points. The framers did not adopt a federal model for the sake of it. The framers were men of deep thought who gave serious consideration to the question of how the Commonwealth would be constituted. We know, for instance, that on every Constitutional Convention meeting, a copy of James Bryce's The American Commonwealth was placed on the table and was studied extensively by delegates. This is important because Bryce's work lays out the benefits of the American federal model that the framers ultimately ended up adopting, including the concepts of states as laboratories of democracy and competitive federalism. Legal conservatives, in my view, must reject any insinuation that the major assumptions underlying Australia's centralism must be accepted. I could refer to the big three provisions that have arguably enabled the most dramatic instances of centralisation: sections 90, 96 and 109. Today, courts could restore Samuel Griffith's original formulation of a section 90 duty of excise that the Commonwealth has an exclusive power to impose as a customs duty imposed upon goods either in relation to quantity or value when produced or manufactured, and not in the sense of a direct tax or personal tax. This would restore considerable revenue-raising capacity to the states and go some way to addressing Australia's crippling vertical fiscal imbalance. Courts could also wind back the reach of Section 96 by referring to the constitutional debates at Federation that the power to make grants to the states was intended as an emergency provision, not as a means of achieving the Commonwealth's day-to-day governmental objectives. At the very least, the scope of Section 96 tied grants could be constrained to policy matters connected to a Commonwealth head of power listed under Section 51. And courts could even take on Section 109, which is rightly despised by federalists, for giving the court licence to invalidate state laws that are deemed to be inconsistent with Commonwealth laws, scrapping the cover the field test that I mentioned earlier, so that it cannot be used to invalidate state laws that are indirectly inconsistent with federal laws, would dramatically constrain its reach. And with a broader curtailment of the heads of powers and a provision such as sections 90 and 96 could revitalise a federalist jurisprudence. What I have outlined in this paper is one framework for legal conservatism, but it is my hope that this is a debate that organisations such as this society continue to have. I believe it is only by putting forward a manifesto for legal conservatism that we can begin to turn the tide of radicalism and restore the traditions this country was founded on. Thank you.